ladies and gentlemen, good evening. I'm Shreya Dhoundial. Exactly 12 days after the President of India greenlit the contentious Waqf Amendment Act, well, the Supreme Court has passed the red light on two of its most controversial clauses. First, the Supreme Court has said that the government will not make appointments to either the Central Waqf Council or the state Waqf boards for the next 7 days. This, a day after the Supreme Court asked the centre if the law will now be changed to allow Muslims on the board of Hindu endowment boards, just like it has been done for the Waqf. The centre has so far not answered that question. But today, it has assured the court that no appointments of non-Muslims will be made to the Waqf till the Supreme Court clears it. Now, the new law mandates that 4 non-Muslims in the 22-strong Waqf councils will be non-Muslims, which the opposition has said is the government's way of controlling the Waqf. But the more controversial clause, ladies and gentlemen, that has been put on hold for the next 7 days is related to Waqf by user. Sounds complicated, but isn't. Waqf by user essentially means that a madrasa or a Eidgah or a community kitchen that may not have a land deed to its name but has been in use for years will be considered Waqf property. The 2013 law codified this. Now, the new law passed in 2025 does not recognize Waqf by user unless it is registered. The concern of the Muslim community is that of the 8 lakh plus Waqf properties across India, half are Waqf by user. The fear is that the government will take over these properties. Today, the court has said that no Waqf property will be denotified till the next date of hearing. I just want to be very clear here. There is no interim stay on the law. Just a pause on some of its more controversial clauses. 3 of them actually. The petitioners, some 70 of them, 70 plus actually, have contended that Waqf, including their creation, management and administration, constitute an integral aspect of the practice of Islam and are therefore entitled to constitutional protection. However, the government has defended the amendments as measures that are aimed at ensuring greater transparency and accountability. Here are some reactions that have come after today's Supreme Court pause. Listen in.
This is not reform. It is retaliation in the guise of reform. It is retaliation meticulously scripted, strategically timed, and constitutionally questionable. The Waqf Amendment Act is not an exercise in efficiency as it pretends to be. It is an exercise in erasure.
The Honorable Supreme Court, as rightly pointed out by my counsel, Mr. Nizam Pasha, the Supreme Court has said that the Central Waqf Council and the State Waqf Boards will not be constituted. Waqf by user cannot be deleted. Now, there are other provisions also which we as a party have come to the Honorable Supreme Court that calling it unconstitutional. Now, whenever it will be heard, our counsel, Mr. Nizam Pasha, on behalf of me, will be arguing it.
जिस तरह का ऑब्जर्वेशन और जिस तरह के कोर्ट में बातचीत हो रही है, हमें उम्मीद है कि मुस्लिम और खासकर माइनॉरिटीज के लिए जो हमारे संविधान में व्यवस्था है कि उनका अधिकार है, अपनी स्वतंत्रता है, उस पर सुप्रीम कोर्ट जरूर विचार करेगा, क्योंकि भारतीय जनता पार्टी मनमानी करती है। भारतीय जनता पार्टी मन विधान से देश को चलाना चाहती है, संविधान से नहीं चलाना चाहती, मन।
There's nothing unusual in the order that has been passed. It is an established judicial practice that in important cases which raise substantial questions of law to be considered at a later date, the court always says that in the interim, the status quo should be respected. All that the interim order means is that till the next date of hearing, or for a week, as far as the appointments to the Waqf councils and Waqf Board are concerned, everything should be kept as it is.
Now, the matter is legal. It is slightly complicated as well. We'll try and get some clarity over the next 8 to 10 minutes. Courtesy Dushyant Dave, senior advocate, also a former president of the Supreme Court Bar Association, joining us on the broadcast. Mr. Dave, good evening and thank you very much for your time. It's interesting to see the reactions that have come in. One party is saying, well, nothing unusual or abnormal about what the Supreme Court has said today. The other party is almost celebrating it like a victory, like an interim stay has been put on the law itself. How should we read what has happened in the Supreme Court?
You see, there is no doubt about the fact that this is a great relief to the Muslim community. And coming as it does in the wake of, Citizenship Amendment Act, a series of attacks on Muslim community in the name of, love jihad, hijab, and then, bulldozer justice. I think this, the slogan that Prime Minister had very beautifully, come out with, Sabka Saath, Sabka Vikas, that slogan has been really thrown into a dustbin. And this, I must say, that today's Supreme Court intervention is not only timely, but it is absolutely a greatest, I would say, a greatest relief to the Constitution of India. Because Article 25 and 26 allow every one of us, be it a Hindu, Muslim, Christian, Sikh, everybody, an absolute right insofar as freedom of religion is concerned. And also to administer our religious affairs and, do whatever we want to do with our, beliefs. So the Act, Waqf Amendment Act, frankly, is a direct attack on the Muslim community and their right, to really profess, create waqfs and administer them for, pious, charitable, religious purposes as their, religion tells them to do. So I don't think, this was really needed. This act is, according to me, a majoritarian act. It is, I would say, it is a sad act. And it is completely contrary to what the constitutional framers had wanted. Shreya, you must remember one thing, that, and this is where BJP really is making a mistake, that the provisions for fundamental rights and the minority communities have come under the chairmanship of late Sardar Vallabhbhai Patel, who was the chairman of both these committees when Constitution was being drafted. And it is he who said that ultimately, if we want to have progress in this country, we want to live peacefully, these provisions are an absolute must. So why is it that BJP forgetting that their own icon, everybody's icon, really spoke for, doing something good for both all the communities, including the Muslims?
Okay. Mr. Dave, can I then ask you, the government of India has argued this in court, has argued this in parliament, has argued it at every public platform, that the Waqf and the amendment is not about religion. It has nothing to do with Islam. It has everything to do with property. This is a property matter. This is not a religious matter. Mr. Dave, we have to accept that the Waqf Board or Council has been a pot of corruption and manmani. They have a habit of getting up in the morning, deciding the Eden Garden or even Fort William in Calcutta are Waqf property and lay claim to it. So there is a problem with it. Now, if the government says this is not a matter of Islam, this is a matter of property, this is a matter of Allah's property. It needs to be clean. Everything needs to be registered. Everything needs to be transparent and accountable. That is why we are getting in the bill. What is the counter argument to that? What can be the counter argument to that, sir?
The counter argument is simple. Which is the institution, be it majoritarian or not? Which is a trust? Which is a society? Which is a social organization where there is, not mismanagement? Is government going to interfere in all those? No, it is wanting to do it in respect of, and the answer to this is individual. If there is one particular waqf where there is mismanagement, you have enough provisions in the existing law to deal with that. So this is a non-starter, this argument. Frankly, there is no doubt about the fact that the act is unconstitutional in many sense, more than one sense. Take, for example, user. Now, user, waqf by user has been recognized expressly by the Supreme Court in the famous Ayodhya Ram Janmabhoomi document. Now, they have said that for centuries, Waqf by user has been accepted, and they said that jurisprudence of this country recognizes that. Now, if that is be so, they said that Section 3, sub-rule R in that old provision, which recognized Waqf by user, was a good provision. Now, if Supreme Court has said that you want to take advantage of the judgment in so far as the Ayodhya temple is concerned, but when it comes to the Muslim community, you say, no, we will give this provision a go by. I don't think, frankly, let me tell you one thing. For almost 77 years, Supreme Court has interpreted Articles 25 and 26, not just in respect of the minority community. Even when the attacks took place by the state in respect of Hindu, religious properties, be it in Tamil Nadu, Madras state, be it in Bombay under the Bombay Public Trust Act, be it in Orissa, in every one of those provisions were challenged and were declared to be unconstitutional. Supreme Court holding that this is an absolute right. In the garb of administration of this religious institution, you can't interfere with this right, which is sacrosanct. So all these arguments, frankly, are really, I'm really shocked that government can come out with these arguments. I don't think government is well advised on this, and government should really rethink about this amending act.
Mr. Dave, then let me ask you a question many people are asking. And look, not everyone has your legal knowledge or acumen, but this is a simple, basic question. Waqf by user means what? Waqf by user means that if there is a Eidgah, madrasa, anything, a Qabristan, etc., that has been in use for many, many years, is publicly recognized as, an Eidgah or a madrasa or a Qabristan, then it is taken as Waqf property. It's called Waqf by user, right? That is what it means, simply put. Now my point is, and this is a point that the government makes as well, and this is a point that I will agree to as a citizen as well, Mr. Dave, if there is government land, somewhere in the back of beyond in India, and a madrasa or a community kitchen is running there for the last 20 years, how is it fair to हड़पो it or appropriate it under Waqf by user? है तो वो government land ना? आपने illegally उसको occupy किया है. You have, set up a madrasa or a kitchen, community kitchen there. Then the government has every right to take it back.
Give me a single example, madam. Don't give this hypothetical example. Give me a single example where this has happened. This is a bogus argument. And let me tell you one more thing. Under the Limitation Act, if property has been taken over by somebody, private property, let's say my land, supposing you take over and for 20, 30 years I sleep over it, knowing full well that you are sitting on it, I lose my right. This is all, these are childish arguments, if I may say so with utmost respect. Government must come out with factual position in a given situation. If somebody has taken away the land, of course, there is a provision in the act that to retrieve it. But to say, because you see, these waqfs have been created for 500, 600, 700 years, and they've been used as such. You can't today be asking that, I'll tell you a simple example. For example, there are many religious properties belonging to the Hindus in which farmans were issued by Emperor Akbar, Shah Jahan and Jahangir. And those properties are existing even today in Mathura and other places. So, this was part, religion is a very beautiful concept. It's part of our lives. And these arguments are completely, I would say, nonsensical, with great respect to the government. That, yes, if you have a given case, please come. But don't justify it on these hypotheticals. Please, this is not fair. And I'm really surprised that you are putting that question. I mean, you are a responsible journalist. You shouldn't be talking in hypothetical issues like this. Sorry, I don't agree with you.
Mr. Dave, it's my job to ask questions.
No, not
Mr. Dave, it's my job to ask questions that people are asking. Now, social media.
That's why I'm asking you.
I have one last question. I have one last question, Mr. Dave. And again, I agree that social media is not the most intelligent place that throws up most intelligent questions. But if there are questions, they need to be answered. Like we always say in journalism, there are no stupid questions, only stupid answers. Mr. Dave, my last question to you is this. And it is on the role of the Supreme Court. The fact is that the Supreme Court not very long ago, in fact this week itself, has told the governors, in fact the President of India as well, that if a state assembly passes a law, you are no one to be a roadblock. Your job is not that. Is the Supreme Court then doing exactly that? After all, it was exactly only 12 days ago that the President of India has signed on to the law. Now, if the Parliament of this country has spoken. And if the people of this country, via the Parliament of this country, have spoken, should the Supreme Court be interfering?
Fortunately, constitutional framers were much wiser than you and me are. And therefore, they provided an absolute, a checks and balance. And they said that Parliament and legislature have powers. But if they exceed their powers, then here is the Supreme Court. And they created Article 32, which is a fundamental right. And that says that if fundamental rights of citizens are violated, Supreme Court has a bounden duty to interfere. And the amending act prima facie violates fundamental rights under Articles 25 and 26. Supreme Court is bound to interfere. Supreme Court has interfered time and again in these issues, and Supreme Court must go on doing. Fortunately for us, we have today a Supreme Court which is alive to the situation on the ground. What had happened in last 10 years, sadly, the Supreme Court really went astray. And I am so happy that under the leadership of Chief Justice Khanna, the Supreme Court today is able to speak, freely and uphold the Constitution. So that's something which citizens must respect, citizens must appreciate, and citizens must pray that Supreme Court gets the same strength in years to come.
Okay, and just to answer your question, I will agree that I'm guilty to a quick Google check, Mr. Dave. You asked me, ऐसा कहाँ पे हुआ है, where the Waqf has been sitting on government land and has not been able to reclaim it. It seems that it has happened in Uttar Pradesh. Some 24 hours ago, some 58 acres of Waqf land in a place called Kaushambi have been registered now as government property. They've been reclaimed from the Waqf and been registered as government property. Anyhow, we'll leave it there. The argument in the Supreme Court is going to...
Let me tell you one thing. What happens in UP is seriously questionable. It's one state which is pushing Muslims to the wall. It's become a laboratory state. And I'm not proud of it. I'm an Indian. So are you. We are all proud of our country. But this kind of a treatment is really unacceptable.
Okay, Mr. Dave, we'll leave it there for the moment. Good to have you on the show. Thank you very much for your views. Ladies and gentlemen, that was Dushyant Dave, a senior, thank you sir, senior and respected lawyer talking to us about what he makes of what the Supreme Court has done as far as the Waqf law is concerned today.